decade, and welcome to Constangy TV's Close Up on Workplace Law, where we zoom in on recent developments of interest to employers, to their attorneys, and to the human resources professionals. I'm your host, Leigh Tyson, and I am a partner in Constangy's Atlanta office. So what's up for employers in 2020? Every year in January, we do a show and kind of consider what happened last year and think about what may happen next year. It's sort of our crystal ball psychic show. And this year, we're very lucky to have David Steffen with us. And David is a partner in our Tampa office, and he's an experienced litigator. He works in all different areas of labor and employment law, including discrimination and wage hour and traditional labor. So he's a great guy to come in here today and tell us what he thinks is in store for employers in 2020. So David, welcome.
Thanks, Lee. Happy to be here. Hope I can contribute.
Last year we talked to Tim Newton, and we actually didn't have that much to talk about. Tim is a partner in the Atlanta office with me, and we were kind of going over what happened to 2018, what we expected for 2019. And I mean, we still talked quite a bit, but there wasn't a whole lot that happened. Has 2019 been different, and can we expect more from 2020?
I would say it was a good year, not a great year. It could have been a lot worse. The biggest thing that's really happened is a lot of these major positions with regards in the government have finally been filled. The Senate's finally gotten around to confirm some very important slots with Trump's nominees. So if 2019 wasn't that exciting, it lends itself for a good 2020, I think.
We've been pretty happy. I wouldn't say that I wake up every morning and just can't wait to see what the NLRB has done, but actually, no, I totally do wake up every morning and can't wait to see what the NLRB is. So, I have no life.
The NLRB under the Trump administration, and I should say his appointees, have done some very good things for not only our unionized workforces across the country, but for our non-unionized employers. And some of these decisions and the new regulations that have come out are really going to help non-unionized workforces continue to stay that way. And the first example of that is, as everybody probably remembers, what we thought were some pretty overbearing regulations with regards to just union elections. Well, the board has scaled that back with its new regulations. It's allowing employers, it's going to provide us the opportunity to have some more time to communicate with employees during organizing campaigns, and it's going to give us a better opportunity to get our message across as to why individual employees really don't want to be part of a union, and it's not to their benefit. So I think that's going to be a big help for everybody across the country.
Were more practical issues that I thought really went to employee rights. I had an issue with the fact that the NLRB was saying that it was okay during union campaign for people to use racial slurs and to make terrible comments at other people who were crossing the picket line. And the previous law was that was acceptable conduct and that was protected conduct, and that an employer could not discipline somebody for engaging in that conduct. And I'm happy to see that the current board is taking that into consideration and has requested briefs on that. But along those same lines, the confidentiality provisions. We do a lot of investigations of sexual harassment, and it's always been very important to us to make sure that that stays confidential, not just for the person who's reporting it, but for the person who is being accused, because maybe it's not true.
Confidentiality provisions under the NLRB were one of the great overreaches of the last decade.
Yeah, the new standard, presumptively lawful. That makes sense to me. If you're doing something really bad that says employees can't talk to anyone and can't talk to their union and can't talk to third parties, yeah, and I can understand that being a problem, but trying to maintain some confidentiality should be within an employer's power.
So I guess our third big thing with regards to the NLRB is a case called Purple Communication. And what they had said was, if the company has an email system and it allows its employees to use that system for work, the employees, or the union in this case, should be allowed to use that system as well to communicate with the individual employees as long as it was during non-working time. Now, that was a real overreach in my opinion, because it allowed the union to use company equipment to communicate with them. So that's been scaled back.
That makes sense as long as the employer isn't singling out union activities. And I think that's the big question mark is what's the caveat there? You still can't discriminate against email usage because of the content, because it's union related content. And so the question is that we're all using our emails, our work emails for all kinds of things. I may be buying something on Amazon. I probably am buying something on Amazon. If that's permitted by my employer, does that mean that they also have to permit it when I start sending out email solicitations about unionization? Okay, next up, let's talk about the new overtime rules that just went into effect on January 1st of 2020.
It could have been worse, and we're just going to assume everybody knows that they went into effect. However, I won't let this serve as confession, but I mean, I know there's some employers out there who haven't put them in place or don't fully understand what the overtime rules mean and with our exemptions.
This is probably a good time to say that if you haven't already put anything into effect, let this be a little reminder to you that now is the time to go ahead and get that going.
I agree with it. And if while you're doing that, it might also be a good time if you know you're making other mistakes or you're not compliant with other parts of the law. We can always use the new regulations as an excuse to roll out a new plan that should be more compliant with the Fair Labor Standards Act. The Supreme Court is currently reviewing a couple matters with regards to an employee's sexual orientation and also gender identity issues. The Supreme Court's taking the cases up. The cases were already heard back in 2019, so we'll probably get a decision this spring, and if not then, we'll certainly have one by the end of June this year when the court closes its session. Second issue that's come out of the Supreme Court is arbitration. Well, it's not very sexy and it's certainly not headline grabbing. It does have a big impact on day-to-day lives of not only employees, but how we move forward as employers. The Supreme Court has reaffirmed its position that it is what I'd just say a big fan of the Federal Arbitration Act and the right of parties to contract away their ability to go to court. Instead of going to court, they have upheld numerous arbitration agreements that force parties into private arbitration rather than going straight to litigation in a federal court. Now, there's one exception to that. The exception is the transportation industry.
Okay, what's going on at the state law level?
The big one that jumped out to me in 2019 was hairstyle discrimination. But what do we mean by it? What courts have said is, these laws have said is you can't discriminate against somebody because of their hairstyle. And what they're looking at is traditionally ethnic hairstyles. The one that always comes to mind for me is dreadlocks. They're actually in some of the more what we'd consider employer-friendly or conservative states like Alabama, there actually have been some pro-employee legislation passed as well. In 2019, Alabama passed a law prohibiting employers from asking employees about their wage or salary history.
Marijuana and all of that litigation, which we hear about on a daily basis.
Marijuana is going to be a never-ending source of work for us, I think. And the big thing with that is we need to know what our local law says, because in some states we may be required to accommodate somebody based upon their use of medical marijuana. Some states and locales have talked about prohibiting drug tests that include marijuana in the drug test.
All right, any other hot issues on the state level?
Paid leave laws are starting to gain some more traction as we come into an election year. A lot of times when a company settles its claims, they include some type of a non-disclosure agreement in the settlement agreement. Oftentimes it's just a basic confidentiality agreement limiting people or even prohibiting them from talking about the settlement. Well, some states have, in the Me Too era, have tried to curb or flat out eliminate non-disclosure agreements because they think that's what's helped facilitate the Harvey Weinsteins of this world, where people have signed their settlement agreements, they're prohibited from talking about it, and so they just go on to the next victim.
David, we actually had a lot to talk about today. This was so much fun. Thank you.
Well, thanks for the invitation. Happy to do it. And I agree. Maybe 2019 wasn't nearly as boring as we thought.
Who knew? Okay. And that's it for this edition of Close Up on Workplace Law. Thank you so much for joining us and hoping to see you again next time. Bye-bye.